Next up is the draft Non-Discrimination in Employment and Housing Practices Ordinance and Materials, presented by Randy Pfeiffer.
Hello. What you have before you is a lot of material on the topic of a potential non-discrimination ordinance for Moscow. And what I think probably might help to begin with as an introduction is a quick run-through of some of the features that highlight the ordinance. And I'd be happy to answer any questions also. At this point, I will say that it's my understanding that part of what would be requested would be some format for public input. So if it's all right, I'll just go through a slide presentation that, because I know that I gave you a fairly voluminous memo with attachments and all kinds of stuff in that. So to begin with, the idea would be that the City of Moscow, as the governmental regulator, would create a law that would prohibit discrimination in housing, certain uses, and employment practices. And it would be added to our code in Title 10, which is Police Regulations, at Chapter 19. So it begins by limiting its scope to two areas that would be forbidden for discrimination. The reason for that is that the federal government prohibits certain kinds of discrimination, but it does not contain the words sexual orientation or gender identity expression. So this ordinance would fill that gap because there's a lack in the state level and in the federal level of regulation for those things. So sexual orientation, actual or perceived homosexuality, heterosexuality, and or bisexuality. So someone's sexual practices, or the perception that they might have those sexual practices or attitudes. And then gender identity expression is the idea of certain characteristics that might have to do with the defining of someone's gender, the way they look, the way they act, the way they think, all these kinds of things. And the idea would be that those are really inconsequential and not important in trying to make decisions about whether somebody can go into a place of public accommodation, whether they could rent from somebody, whether they could get or keep a job, whether they can advance in their careers. So what we're simply saying is that that won't matter. If it does matter, that's against the code and there are some consequences to it. Now, as part of what this ordinance does, and it's unlike a lot of other ordinances, it spends a lot of time in what the ordinance does not do and what the ordinance does not cover, because we don't want to run afoul of the preemption doctrine, which is that if another governmental entity superior to our own occupies the space in the law in a certain topic, then that takes it away from the city's regulation unless it's specifically given to the city. So, for example, daycare, the reason the city has a daycare ordinance is because the state, even though it decided to regulate daycare, allows cities to continue regulating daycare as long as they do it within a certain way. This does the same thing, and that's why if you look at our the proposal, it spends a lot of time on saying that we're not doing things that the state does and we're not doing things that the federal government does. In addition to that, because of the First Amendment and the right to associate with people and to not associate with people, The longest definition in here is what is a public place, basically, or a place open to the public or used by the public. And without going through everything, certainly the public can look at that. It talks about places where you can eat and drink and sleep and talk and go to sports or entertainment events, recreate, and to get medical treatment or other kinds of treatment, places that you store things, vehicles and other kinds of things, public bathrooms and restrooms and things that are open to the public. And also, in this case, structures occupied by 2 or more tenants, or the owner and 1 or more tenants, libraries, educational institutions, and all kinds of places open to the public, except for, at the very bottom, you'll see that it doesn't apply to things that are strictly private. And it also doesn't apply to educational facilities that are operated or maintained by bona fide religious or sectarian institutions. So it doesn't regulate those. So those are the main definitions. There are lots of definitions in the ordinance, but let me talk to the areas that we would be with this regulation governing. One would be employment. It would prohibit employment discrimination. For example, failing or refusing to hire someone because of their sexual orientation or their gender identity expression, discharging them because of it, barring them from employment or other kinds of discrimination, not giving them the right shift, they can't qualify for certain promotions, or that you don't send them to training, or you send others to training instead of them, or compensation, those kinds of things in employment, if they're otherwise qualified. And that's important because if some person comes in and they're not qualified, this does not force somebody to hire them in a position for which they aren't qualified. But if they are, then they should have the same opportunity in that job position as anyone else would. Now moving to number 2, uses of places open to public. That's my shorthand for the longer definition, place of public resort, accommodation, assemblage, and or amusement. But the idea is that anyone should be able to, in our town, go into a place that's open to the public and enjoy that in the same way that anyone else can. So if there was someone who wouldn't serve a drink to somebody, or they kick them out of a movie house, or they say you're not welcome here to this public event, or this event that's open to the public, that would be a violation of this ordinance. The third would be housing. Because of someone's sexual orientation or because of their gender identity or expression, you won't sell them a house, you won't lease an apartment to them, you won't rent something to them, or you won't allow them to purchase or to sell something that's a house. Also, discrimination, someone who refuses to help repair a house because they don't like the kind of they don't agree with or don't like the kind of thing that their sexual orientation or their gender identity expression. So it eliminates those. Now, it doesn't, and Ken Nagy's here, he's the expert in the room, I'm sure, on housing violations for other things that are regulated. But this would only take care of those 2 elements of housing. Sexual orientation and gender identity expression. So those are the areas that it would regulate. Let's move forward. There are some exceptions, as I said before. It exempts religious entities from regulation. It exempts expressive associations. That's the Boy Scout case. And the reason I gave it to those who really wanted to read that long Supreme Court case is because there is an exemption related to people who have similar values and similar stated goals. They should be able, according to the Supreme Court, to associate with one another. That's a very similar idea to the old Elks Club, Lions Club, Rotary Club cases where women were excluded and now they are included. But it's a fairly recent Supreme Court case, and it allows the Boy Scouts, for example, to say that they don't want to have gay people in either as members or as people who provide Boy Scout services. So because that is a current First Amendment issue, I included it. It was also included in Salt Lake City's and Boise's. And it seemed prudent to follow that so that the city of Moscow doesn't run afoul of the First Amendment in that particular area. It excludes governments and other agencies because the city has always steered clear from regulating other governments and governmental agencies. It also excludes two-family dwellings where the owner or relative lives in one of the units and rooms in a boarding house. Now, those are analogous to what Boise did and what Salt Lake City did, but certainly all of these are up for discussion if you wanted to broaden or narrow the exclusion on people who live closely with other people. And that's sort of the idea here, is that if you're in a duplex and you live in one side of the duplex and you are not willing or do not want to rent the other side of the duplex to a person because of their sexual orientation or gender identity expression, you don't need to. Now, depending on what Moscow wants to do, that could be changed. But that's why it's there, is because one of the things I did in order to have a starting point for the discussion about what Moscow wishes to do or not do is to try to look at some other successful areas that may have some things in common with our state. And I will also say that this is in the draft for Pocatello consideration, and it's similar to what else has been done in the state, those two parts about housing dwelling units. Moving forward, strictly private clubs or institutions, that was from that definition that I talked about, and so was educational facilities owned by religious groups.
Strictly private clubs would be defined as?
That's a little bit more difficult. Membership only, certain requirements that aren't based upon discriminatory activities.
I guess
probably limited membership.
Most of the normal fraternal organizations, Elks, Moose, Eagles.
They would not fall into that.
They do not fall into that
That's
category.
correct.
Right.
Yeah. Let's see. The penalties that are proposed, and I'll show you in the flow chart how it fits together, but our code violations are misdemeanors as the default penalty, unless that says specifically that it is an infraction. The difference is the misdemeanors have the potential of arrest if the misdemeanor is happens in the presence of a police officer, and potential jail time if the judge decides to give jail time for the violation, in addition to a fine. An infraction is fine only. It's not an arrestable offense, and it doesn't go on a misdemeanor record. It's just a monetary penalty. That's another decision that the council can make about what to do here. I chose to put the draft in as a misdemeanor because that is what has been done elsewhere in Idaho. And I felt that the city of Moscow probably as a starting point would want to do at least what the other cities in Idaho have done relative to the penalty.
And that would be the criminal approach?
Correct.
Thank you.
So other features, it doesn't cover laws or regulations that handle other forms of discrimination. It's limited to only those two areas that I've mentioned. Not strictly private clubs or institutions. It doesn't cover educational facilities owned by religious groups. It prohibits retaliation for reporting or cooperating with the claim, so that people don't have to worry that they made a claim and they're going to get in trouble for just filing it. It also does not create a private right or cause of action or money damages for other people. So it's strictly a city activity and a city action that would result, hopefully, in compliance.